Okay, let's begin. Good evening and welcome. My name's Terry Link, and on behalf of the Greater Lansing United Nations Association and the Peace Education Center, I am pleased to welcome you to explore with Professor Brad Roth how international courts might prevent armed conflict. This program is being recorded, and we will upload it to our website in the coming weeks. This evening's program is part of a larger set of programs we call PeaceQuest Greater Lansing that celebrates the International Day of Peace on September 21st, and which we and other organizations in the Lansing area recognize throughout the month of September. To see more of the events, please visit our website at peacequestgreaterlansing.org. The increasing spread of war in recent years is concerning to us all, especially to those directly impacted by the loss of life, limb, community, and any sense of security. The United Nations was born out of the ashes of World War II in hopes to prevent armed conflict and to develop a set of agreed upon principles and rules to reduce the threats of violence and to increase security and opportunity for all. International laws have been established that address the issues leading to and resulting from armed conflict. Notably, recent attention on both the International Court of Justice and the International Criminal Court over the conflict between Israel and Palestine and Russia and Ukraine has brought those legal bodies' roles more into the headlines. Tonight, with the able assistance of Dr. Brad Roth, we will look at the development of international law regarding armed conflict and what we might hope of it, as well as its limitations at the present moment. Before I introduce Professor Roth, though, let me put in a plug for the two sponsors of this program. The Greater Lansing United Nations has been working tirelessly for decades to support the ideals of the UN Charter and to raise public awareness of the many activities the UN works on to build a better future for all. Please visit the website at www.gluna.org to stay abreast of our programs, join as members, donate, or follow us on Facebook. The Peace Education Center, like Gluna, is primarily an all-volunteer organization that for 50 years has been a voice against war and violence and for building a more just and equitable society. You can visit the PEC website at peaceedcenter.org to follow our programs, actions, important news, and other resources, or again, follow us on Facebook. Dr. Brad Roth is currently a visiting scholar at Queen's University in Belfast. So tonight, he's speaking to us at just past midnight his time. What a remarkable gift to us. Back home, he holds a joint appointment with the School of Law and the Department of Political Science at my alma mater, Wayne State University. He specializes in international law, comparative public law, and political and legal theory. His courses include law, authority and resistance, international law, international protection of human rights, international prosecution of state actors, U.S. foreign relations law, and political theory of public law. He is the author of a number of books, including Sovereign Equality and Moral Disagreement by Oxford University Press in 2011, Governmental Illegitimacy in International Law, again by Oxford University Press in 1999, and with co-editor Gregory Fox and Paul Dubinsky, Supreme Law of the Line, Debating the Contemporary Effects of Treaties Within the United States Legal System. That was by Cambridge University Press in 2017. And with Gregory Fox, Democratic Governance and International Law, again, Cambridge University Press in 2000. So he's been a busy guy. On top of that, he's authored at least 50 book chapters, journal articles, and commentaries dealing with the questions of sovereignty, constitutionalism, human rights, and democracy. Most recently, as co-editor with Gregory Fox of Democracy and International Law, published in 2020. He is speaking to us at midnight his time, as I've mentioned, a sure sign that he is dedicated to help us better understand the role of international law in constraining armed conflict, and maybe even what we might do to help strengthen it. After he concludes his presentation, he will stick around for about 30 minutes to answer some questions that you might have. So please, during his presentation, if you have questions, write them into the chat, and we will get to as many as we can. I hope you will now take some moments and give him a thumbs up and appreciation for his willingness to be part of this and to help us understand better where international law might be able to take us. Brad, please.
Thank you, Terry. That's all very kind, and it's very nice to be with you all this evening, or tonight, as it were, for me. There is a document which is posted in the chat, which I'm not going to do the screen share thing because that's really annoying. And the document is not exactly an outline of the talk, but it contains a whole series of frameworks for you, and I will be touching on aspects of what's in that document in order to try to elucidate some of the key points about the role of international courts in dealing with, or not dealing with, as the case may be, international conflict. We are currently in a moment when international courts have had a high profile in dealing with international conflicts. And particularly with respect to the conflict in Ukraine and the conflict in Israel-Palestine, where both the International Court of Justice and the International Criminal Court have become involved. They have become involved in rather constrained ways, and it is undoubtedly going to be a source of great frustration to many people that the courts are not able to fully take on many of the issues that need to be addressed from the standpoint of international political morality. And also going to be even more frustrating that whatever the courts may do will not be subject to coercive implementation in any very effective way. Still in all, I think it's important to note the role of international courts in further specifying the implications of international law for particular conflicts and providing a rallying point for opposition to belligerent policies being undertaken in various parts of the world. And I'll try to explain at the end why I think that despite all of the limitations of the international legal order, that nonetheless there is something to be valued in these kinds of efforts to get international courts to address armed conflict. Interestingly, the United States government has gone to great lengths to try to keep international courts from dealing with questions of armed conflict as a supposed matter of principle, and has repeatedly either withdrawn from jurisdiction of courts dealing with those matters, or has refused to accept the jurisdiction of courts that might deal with armed conflicts. And so we see a real clash of perspectives. And the United States, of course, always claims to be supporting a rules-based international order. But remarkably, that doesn't really mean international law abidingness. That means rules as dictated by the United States. And so we see a tendency toward disrespect for international law and international legal institutions in the realm of armed conflict by United States governments of both parties. And this has been a trend against which many of us have been pushing back over the years, not with great success, but hope always persists. And so what I want to do is to acquaint you with the basics of the international legal order, assuming that most people don't have an intuitive grasp of how the international legal order works, how counterintuitive it actually is, how much it differs from a domestic legal order, and then try to highlight the role of international courts, what international courts can do, what they can't do in respect of these matters. And so again, I've put together this outline, which will have to be reposted in the chat repeatedly because new people coming on to the program here aren't going to be able to see it otherwise. So the outline tries to lay out for you a bit about the international legal order. And first, to point out the basic nature of the international legal order, it is a horizontal legal order. It is based upon the idea of the sovereign equality of states. It therefore does not have the kind of hierarchy that would ordinarily exist in a domestic legal order. Most importantly, it does not create the capacity for decisions to be taken through a kind of legislative process where a majority binds the minority. It is a situation in which the sources of authority are also the subjects of the authority. The states are the main players in the international system, and states are presumptively free, except to the extent that they can be said to be bound through something that is at least notionally a product of their own will. And so you start from the idea of states as self-sufficient sources of legal authority, and the international legal order is built around that idea. But that basic premise of the sovereignty of states is constraining. And whether that is a feature or a bug is itself a complex question. It's ordinarily a source of frustration for many people who want to see a stronger hand in the international legal order. But I would want to argue that in many ways, the kinds of or perceived inadequacies of the international legal system actually work to the benefit of weak states vis-a-vis strong states, and that in many ways could be a positive thing for international legal order. The international system is, after all, a system of units that have very different levels of power, very different interests, and in many ways different values. And so a system of sovereign equality is a framework of accommodation among those different actors. And basically, the logic of the system is that powerful states can get what they want without law, but with great transactions costs. And so the routinization of international order is significant from the standpoint of powerful states. And powerful states are therefore willing to yield something in the service of that regularization of international conduct. And the key question for those of us who are advocates for international law a lot of the time is to prevent the powerful states from having their cake and eating it too, to prevent the powerful states from dictating the terms of the international system by virtue of their superior power and influence, but also breaching the very rules that they set for themselves. And this is a major problem in the international legal system. But there are some notable successes in sort of imposing legal order, at least on particular realms of conduct. And so the glass is a quarter full rather than 3/4 empty, I would want to say. So the basic principles of the international system, as I mentioned, are the sovereign equality of states, and the idea is that states are manifestations of the self-determination of their territorial populations. And so the law of self-determination of peoples is very much bound up with the idea of the sovereign equality of states. That particularly has reference to circumstances of decolonization. Of the original sin of the international legal order is understood broadly to be colonialism. Colonialism still existed at the time of the inception of the current international legal order, Peace and Security Order in 1945, the UN Charter, but the UN Charter had within it the seeds of the destruction of the colonial system. And about 15 years into the UN order, there was a systematic repudiation of what might be called saltwater colonialism, and the idea of self-determination as a basis for a right of sovereign independence of what were called non-self-governing territories became institutionalized. And the question of self-determination of peoples becomes very relevant to the question of peace and security when we're dealing with conflict over territory that is slated for self-determination. And the crucial issue in the Israel-Palestine conflict is that the Palestinian people have long been understood as a people with a right of self-determination, which is a right to determine their political status and freely pursue their economic, social, and cultural development. And insofar as that right has been denied, that has been a focal point for international attention over a long period of time. And it's been a focal point of attention, some might say disproportionately, because people might argue that there have been worse atrocities that have been committed elsewhere in the world, that there are human rights violations all over the place. Why fixate on this particular aspect? But the Israeli-Palestinian conflict is something that has always been under the jurisdiction of the United Nations system. From the termination of the British Mandate in the late 1940s, the United Nations has been fixated on this question ever since of resolving the problem of mutual self-determination of two peoples in that land. And that is seen as being in a different category from human rights violations in other contexts. Human rights violations are generally understood as rights violations within the scope of sovereign states. That's, perhaps unfortunately in the international system put in a different and subordinate category. Conflicts between states and non-self-governing territories are seen at a different point in the international legal hierarchy, as it were, and therefore get a special kind of attention. The most fundamental principle of the peace and security order, as has been established, is that no use of force against the territorial integrity or political independence of states can be tolerated. So force is only justified either in self-defense or on the basis of an extraordinary determination by the United Nations Security Council that force can be used to redress threats to the peace, breaches of the peace, or acts of aggression. And so the use of force norm is crucial, and part and parcel of that norm is the idea that territorial acquisition by force is inadmissible. And that is a crucial aspect of the Israel-Palestine conflict, because as is famously recounted in Security Council Resolution 242 in 1967, territorial acquisition by force, whether the war be justified or not in the first instance, is inadmissible in the international system. And we see the International Court of Justice weighing in just in the last month, over the last 2 months, over the question of Israel's treatment of the occupied territories and its effective violation of the principle of non-acquisition of territory by force. There are many other things about the international legal order that perhaps ought to be explored. I wish I could go on at great length about all of the nuances of this, but some of the things just to keep in mind is that international law is applicable within states only insofar as international law is incorporated by the law of the state. And so you have this peculiar situation where you really have law on two different planes, the international plane and the domestic plane. And so states are responsible for their obligations in the international legal system, but the international legal norm is not necessarily effective against individuals or even against state officials directly within the state. That requires a transformation of international law into domestic law on the terms of domestic law. And that has been very frustrating to people in the United States because the United States law only very grudgingly and in a very limited way actually incorporates the international legal obligations of the United States. And so by and large, the state is notionally responsible on the international plane, but the same act could be seen as lawful and unlawful simultaneously, lawful in domestic law, even though a breach of international legal obligation. And so that's one of the paradoxes of the international system. However, there are certain violations of international law that count as international crimes. States in those circumstances have not only renounced the practice, they have renounced the capacity to authorize the practice. And under those circumstances, individuals are directly subject to international law, and therefore, if they end up being unlucky enough to fall within the grasp of a state that has jurisdiction to prosecute, or of an international body that might prosecute them, they are subject to international justice. And the United States, of course, has often been very concerned about the possibility that people who participate in decisions about armed conflict might find themselves subject to international justice. And the United States has taken many measures to thwart that. And they've also taken measures on behalf of Israel to try to protect Israeli officials from this, as we will see. Foreign officials are, generally speaking, immune in the courts of fellow sovereign states. And so ordinarily, individuals cannot be prosecuted for official acts that occur within their own territorial boundaries. However, again, this does not apply to international crimes, generally speaking. And so individuals can, both for crimes committed outside their country and for crimes committed inside their country, be potentially subject to criminal jurisdiction, either in an international tribunal or in the courts of foreign states in ways that we'll get to. The other aspect of immunity, though, is that state officials who engage in diplomatic activity, heads of state, heads of government, and ambassadors, are completely immune for the time that they are in office, because the international system puts a very high value on international diplomacy. And so it doesn't matter what you've done, if you're a head of state, head of government, or ambassador, you cannot be prosecuted until such time as either your own state cuts you loose, and because the state can waive your immunity, the state owns your immunity in those circumstances, or you leave office, and then you can be prosecuted for anything you might otherwise be prosecutable for. This is a significant problem with respect to state officials who are currently in high positions, like heads of state, heads of government, foreign ministers, who have committed international crimes, and sometimes they're in governments that perpetuate themselves indefinitely, so they're never going to step down, and they're never going to be subject to international justice. The international criminal tribunals that have been created have negated this kind of immunity. And so arrest warrants have issued from international tribunals against heads of states, heads of governments, and other such officials. But there's a problem with respect to the arrest warrants that have been sought against Vladimir Putin and against Benjamin Netanyahu for reasons that I'll get to. And it's because there is this basic presumption of immunity, and there are certain steps that have to be taken to overcome that immunity. So I'll get to that more when I speak to the question specifically. Broadly about the international system, when we think about governments, we think about legislatures, executives, and judiciaries. It's not just that those are three branches of the American government, the American constitutional system. Those are the three basic functions of governance as such. We need lawmaking, we need the execution of laws, and we need adjudication. And so those are three sort of basics about the nature of governance. And if you look at the UN system, you might imagine, well, there's a UN General Assembly that looks like a legislature. There's a Security Council that looks like an executive. There's an International Court of Justice that looks like a judiciary. But actually, the international system doesn't really work that way. The UN General Assembly is not a legislature because the majority can't bind the minority. The international legal order is based upon essentially two pillars. One is called customary international law, and the other is treaties. So customary international law are these patterns of state practice that have been undertaken with an understanding that somehow manifested that these practices are a matter of legal obligation rather than simply convenience or courtesy. That states engage in certain routinized practices that over time have come to be understood as a subject of legal obligation. And sometimes United Nations resolutions can reflect that. Indeed, some United Nations resolutions are understood as codifications of existing customary international law. And so they articulate specifically what has come to be understood over time as the law, or sometimes those resolutions anticipate the establishment through customary practice of a particular legal standard. And so UN resolutions are often markers for international law, even though the passing of the resolution itself is not actual legislation. But a lot of UN resolutions, which are unanimous or nearly unanimous, cut across interest groups within the international community and are framed not as exhortations to action generally, but as the language of codification of a legal norm. Those resolutions have legal significance, even though they're not legislation. So that's customary international law. The other part is treaties. Treaties are basically contracts under international law, contracts between states. And so there is a customary law of treaties, which itself, interestingly, has been codified in a treaty about treaties, the Vienna Convention on the Law of Treaties. And so you have a set of standards about how international treaties work. And treaties are either bilateral between two states or multilateral among a great many states, some of them among all the states essentially in the international community. So for example, the Geneva Conventions are subscribed to by all the states in the international communities. So they start to look like legislation, particularly these are treaties, multilateral treaties that form a part of what I refer to as international public order law. They're treaties that are not simply exchanges of reciprocal obligations. They are attempts to establish an international legal framework. And so states become part of these multilateral efforts like the United Nations Charter and like many of the key treaties that deal with questions about the law of armed conflict or international human rights. And those treaties then are binding on states on the basis of their consent. Important to note, though, that in many of these treaties, it's possible for states to make reservations to particular provisions of the treaty, because the treaty, after all, is being undertaken as an act of will. States can accept from those treaties, can say, well, they'll take it a la carte. We'll accept obligations A, B, C, and D, but not E and F. And ordinarily, it's possible for states to do that. And so what we have, because of the system of consent, sort of variable bindingness of particular obligations in the international system. There are some norms that transcend the question of consent. There are some norms that are so foundational to the international order that they're understood by states as being, as they say, non-derogable. There's no circumstance under which there can be exceptions taken to them, and states are bound by them, even if, as we say, they persistently object, even if it's clear that their will is not engaged in the creation of the norm. There are certain kinds of norms, like the norm against genocide, for example, where states are bound irrespective of whether they consent or not. But those are exceptional norms, but still some very foundational ones. So international law, is this set of treaties and customs generally. In terms of executing international law or implementing it, the problem is, again, there is no international executive branch of government. So what you have is states reacting to violations of international law in various ways, sometimes just through the application of their ordinary foreign policies, withholding certain kinds of favors they would give to other states, engaging in discretionary acts of foreign policy that seek to push back against what other states do. But there's also something called countermeasures, where states can actually violate the rights of other states on a proportional basis in a way that is calculated to restore the other state's conformity with the international legal standard. So countermeasures represent a significant aspect of how international law can be in some manner enforced. And then also you have the Security Council, which not simply as an all-purpose enforcer of international legal norms, but where the Security Council regards a violation of an international norm as a threat to the peace. The Security Council, with 9 out of 15 votes, including no vetoes from the permanent 5, can authorize either forcible or non-forcible measures that would otherwise not be available. The non-forcible measures under Article 41 of the Charter are typically economic sanctions, and the forcible measures are allowed under Article 42, authorizing states to use force in furtherance of the Security Council resolution. But absent that kind of measure, and particularly you have the problem of the permanent 5 have a veto, the United States or Russia or other of the permanent 5 states can block the Security Council resolution from authorizing the use of force. In the presence of that veto, we fall back on standards of sort of execution that are really have to do with countermeasures. That leads to our discussion of the judicial system. The judicial system is not really a system. It is a kind of hodgepodge, a patchwork of adjudication and arbitration mechanisms that are established in various ways, usually by states agreeing through treaty to establish the dispute resolution mechanism. The most important of these is the International Court of Justice, which is discussed in the United Nations Charter. The International Court of Justice was reformed after World War II. It was a successor to the Permanent Court of International Justice that had existed in the interwar period. It's really the same court. The International Court of Justice deals with state-to-state disputes. So it's not individuals, it's only states that come before the court. And the International Court of Justice can either decide compulsory jurisdiction cases, or they can give advisory opinions. The compulsory cases only arise where states have agreed one way or other to have their dispute resolved by the International Court of Justice. And that tends to be rather exceptional. There is an all-purpose basis for accepting the jurisdiction of the court under the statute of the International Court of Justice. but it is subject to all kinds of qualifications, and states can decide what sort of topics they are not willing to allow to be basis of compulsory jurisdiction against them. So states can sort of pick and choose in this regard, and can only be sued by states that have similarly consented to the jurisdiction of the ICJ. The other way that states get sued in the ICJ is through what's called a compromissory clause of a multilateral treaty. And so what happens there is that a state, by having, for example, signed on to the Genocide Convention, has signed on to the dispute resolution provision. And so what we've seen very recently is that the International Court of Justice has taken up genocide cases because of the compromissory clause, even though they don't have jurisdiction more broadly. And this is a huge problem in the Ukraine case and the Israel case, because the International Court of Justice does not have general jurisdiction over those states. Those states have not consented to have their conduct in respect of war crimes, or in respect of crimes against humanity, or in respect of aggression. None of those matters are subject to the jurisdiction of the ICJ in either the Russia-Ukraine case or the Israel-Palestine case. And so the court is limited in what it can focus on based upon the limits of its jurisdiction. On the other hand, if the General Assembly asks for an advisory opinion from the International Court of Justice, the International Court of Justice, at its discretion, can confer such a decision. Those decisions are not binding, but they are highly authoritative, and they'll serve just as well for the moment. And so the advisory jurisdiction of the court is quite significant, and we see an advisory opinion on Israel's conduct of the occupation. We've seen now two of those decisions, one in 2004 and one this year, that have essentially condemned the Israeli conduct of the occupation, even though Israel has not consented to compulsory jurisdiction with respect to this matter. It's still just an advisory opinion. Nonetheless, it sets out a position on what the international legal obligations are, not only of Israel, but of states interacting with Israel in respect of the occupation. So there is some room for states to be subjected to international judgment through this process. The International Criminal Court is another court that's created by multilateral treaty. It has 120-odd parties at this point. Not the United States, not Russia, not China. Some other important states are not parties to it. But the International Criminal Court has a jurisdiction over individuals, and can prosecute a limited set of crimes. That is to say, war crimes, crimes against humanity, which are widespread or systematic attacks on a civilian population, or the crime of genocide. In principle, the ICC was supposed to have jurisdiction over the crime of aggression as well. But for complicated reasons, that's never really come to fruition and is not a factor. No one's going to be prosecuted for aggression by the ICC anytime soon. The ICC operates on the basis of a principle of complementarity, which is to say that states are supposed to be given an opportunity to prosecute their own wrongdoers, and only when they prove to be unwilling or unable to do so does the case become admissible before the International Criminal Court. One of the issues that's been raised by Israel in respect of potential prosecution of Israeli leadership is that Israel has not been given appropriate opportunity to clean its own house in that respect. although the counter argument, which seems like a fairly strong one, is one of futility, that there's simply no reason to believe that the Israeli system is anywhere near serious about grappling with the issues that are before the ICC. The ICC also has jurisdiction in cases where the Security Council has conferred jurisdiction by Security Council resolution, but otherwise it has jurisdiction over crimes committed in the territory of states parties or crimes committed within the territory of non-parties that have conferred consent over the situation. And so Palestine, which is recognized as a state by the International Criminal Court, has conferred jurisdiction over the issues in the occupied territories to the ICC. Israel contests that. It doesn't recognize Palestine as a state, but it's going to lose that point because the ICC and other important international bodies do acknowledge Palestine as a state. The ICC also has jurisdiction over the nationals of state parties. It can have jurisdiction, though, over the nationals of non-parties if those nationals of non-parties commit acts within the state that is consented to the jurisdiction, or commit acts that have direct effects within the state. They don't have to be located within the state to subject themselves to the jurisdiction of the court under those circumstances. So you have this possibility of the International Criminal Court addressing these matters. Most of international criminal law up to this point has been a product of international criminal tribunals that have been created outside the scope of all of this. The ICC has existed since 2002 based on a treaty that was concluded in 1998. But before that, there were ad hoc tribunals that were created by the UN Security Council under its special powers, and particularly the International Criminal Tribunal for the former Yugoslavia is responsible for the great bulk of international criminal law jurisprudence. There were about 150 people who were indicted by the ICTY or ICTY as a result of the various conflicts in the former Yugoslavia. Impressive process in that it attempted to prosecute everybody from every side of that conflict. There were 3 states and 4 insurgent organizations involved in those conflicts, and representatives of all of them were subject to indictment. The only participants in the conflict who were not subject to indictment, NATO. The exception that proves the rule: he who pays the piper plays the tune. The ICTY had a basis for engaging in a criminal investigation of acts committed by NATO and particularly United States forces in the bombing of Serbia in 1999 and the Kosovo campaign. They did not do so, and many people have understood that as a significant black mark on the ICTY. But the ICTY is sort of the archetype, and it's really based upon their achievements that the ICC has developed its status. The ICC, however, has done much less than anyone would have expected up to this point. It's existed since 2002. It has so far only convicted low-level operators, and the big fish that it has gone after, it has failed to actually effectively deal with. Although, as a lawyer, I always have to say that acquittals should be welcomed in an international criminal justice process, just as in any criminal justice process that demonstrate the existence of real due process. But it has been frustrating to many people that key figures such as Laurent Gbagbo, the former president of Cote d'Ivoire, or Jean-Pierre Bemba, former opposition leader in the Democratic Republic of the Congo, or Uhuru Kenyatta and William Ruto, presidents of Kenya, have escaped the net in various ways in the ICC. Still in all, the ICC is available to address these conflicts. And interestingly, it has only indicted people on the continent of Africa so far, but it has investigated other cases beyond Africa and is, of course, investigating the case of Israel-Palestine. And now has issued an arrest warrant actually in the against Vladimir Putin in the Ukraine controversy. So we do have movement forward with the ICC in those respects. If I had more time, I would go into some of the domestic court uses of international criminal law, which is something that's made available through a phenomenon called universal jurisdiction, where domestic courts are sort of deputized to be able to address the criminal violations of people outside their state who have no particular connection to their state. So, for example, the dictator of Augusto Pinochet, the dictator of Chile, was prosecuted for acts that he committed against Chileans in Chile, and was apprehended in England. And on the basis of an arrest warrant from Spain. And that case famously led to a decision about whether people could be immune for acts that they committed within the scope of their official capacity when they had violated the torture convention. And the precedent established that indeed Augusto Pinochet could be extradited to Spain to stand trial. Turned out that he wasn't for political reasons, but the precedent was established that people can be subjected to international justice through this network of domestic courts operating on the basis of international treaties, as well as customary international law at this point, that make it possible, at least in principle, for people to be subject to that jurisdiction. Again, so much to cover and so little time, and I do want to give time for questions. But just to say a few things about what's happened in these most recent cases. So, as I say, the International Court of Justice has been dealing with these contentious cases under the Genocide Convention because there is this compromissory clause that allows for jurisdiction over the crime of genocide, but not over anything else. So oddly, the Russians, when they invaded Ukraine, said that, well, the reason why they were invading was because there was a genocide being perpetrated by the Ukrainian government against ethnic Russians inside of Ukraine. And so the Ukrainians cleverly turned this around and sued Russia under the Genocide Convention, claiming that by exploiting the idea of genocide in this way, they were, and using force, they were violating the terms of the Genocide Convention. That kicked around for a while, but most recently, earlier this year, the International Court of Justice essentially invalidated Ukraine's claims there. Ukraine was trying to get the question of Russia's aggression against Ukraine in through the back door, and the court was not allowing itself to get drawn into something over which it did not have jurisdiction. And so there's an aspect of that case that's still ongoing, but it's a relatively trivial aspect. And ultimately, Ukraine has failed to engage the ICJ on that question, not because Ukraine isn't subject to international law violation by Russia, and indeed the court has acknowledged that there are other violations at issue. They simply don't have jurisdiction over those violations. So the Russia's aggression against Ukraine is very real under international law, but the court cannot articulate it directly. On the Israel-Palestine question, South Africa has sued Israel under the Genocide Convention because all states can sue all other states in respect of this matter. The obligations are owed to the international community of states as a whole, or at least to the international community of those states that are parties to the treaty. And so South Africa has sued, and the case is currently in the phase that is the international version of the preliminary injunction phase of domestic litigation. So what's happened is that South Africa has called for provisional measures against Israel. And they have now taken it in 3 rounds to the International Court of Justice. I was at the oral argument for the 3rd round. And the result of that was this very peculiar order that the court issued in terms of Israel's assault on Rafah, this sort of residual area of the Gaza Strip where it is still besieging Hamas and Palestinian civilians, but had not yet entered. And oddly, the court ordered as a provisional measure that Israel immediately halt its military offensive and any other action in the Rafah Governorate which may inflict on the Palestinian group in Gaza conditions of life that could bring about its physical destruction in whole or in part. This is a remarkable statement. The statement is repeated verbatim twice in the court order, which is to say that this is negotiated language and the ambiguities aren't by accident, they're on purpose. And so there are 2 different ways of reading the order. One is to say that it has to immediately halt the military offensive, and it has to halt any other action which may inflict on the Palestinian group in Gaza conditions of life that could bring about its physical destruction in whole or in part. Or it could be read as having the which clause qualify the halting of the military offensive, that it has to halt the military offensive insofar as that military offensive might inflict on the Palestinian group in Gaza conditions of life, which could bring about its physical destruction in whole or in part. The reason for that nuance is the limitation of jurisdiction, that the International Court of Justice does not have general jurisdiction over the equities of Israel's use of force in the Gaza Strip. Those norms exist under international humanitarian law and under international law governing the use of force, but none of that is subject to the jurisdiction of the International Court of Justice in this case. And so all they can do is up to the limits of their Genocide Convention jurisdiction, and thus they kind of fudged the matter and left it unclear exactly what they were ordering the Israelis not to do. And so both sides kind of claimed victory. It was a very exasperating experience. The advisory jurisdiction, though, has been used to much greater effect because the advisory jurisdiction has taken on the question of Israel's occupation of the Palestinian territories, and it has taken the position, the court has taken the position that the nature of the occupation has been such as to vitiate any continued right of Israel as a result of its supposedly defensive war going back to 1967, any residual right of continuing that occupation. That the Israelis have perpetuated the occupation and engaged in systematic illegal purposes in perpetuating that occupation in order to effectively acquire the territory, to effectively annex territory in East Jerusalem and the West Bank in particular. And so the court has demanded effectively that Israel, in as soon a time as feasible, withdraw from those territories. And so and the UN General Assembly has voted to affirm this position, and by a very wide margin. 124 states voted in favor, and 14 states voted against, 7 of which were Pacific Island nations, interestingly. And so there is a sort of mounting momentum against the Israeli occupation as such. The bottom line with all of this, there's so much more to be said, but the bottom line is sort of what good is any of this? Do international courts actually matter for these purposes, given all of these limitations? And I want to argue that indeed, there is something to this. First of all, that there are important moral considerations favoring the distinctively adherence to international legal obligations over and above first order political morality. That is to say, that we may think that things are wrong for direct moral purposes. The fact that they violate international law adds to this, because even people who are not in agreement on the first order political morality have to acknowledge that states, in some sense, honor has been engaged by their acceptance of international norms that have this implication. And since all states reap the benefits of mutual norm compliance, and normlessness is costly to everyone, there is a moral interest that states have in upholding an international legal order that brings some order to the chaos of international relations. And those obligations hold even in the face of what some people would think of as a moral objective. So even if people are not persuaded that you're right on the moral merits, they may have to concede that you're right on the legal merits and that that has moral implications. And it's also important for prudential reasons, I think somewhat cynical ways. I mean, I always say that winners can be able to get away with violations of international law. But if you roll the dice in violation of international law and it doesn't work out for you and you need people to come to your assistance, then that's not going to go so well for you if you're seen as an international lawbreaker. And being seen as an international lawbreaker can have significant downstream effects on your capacity to be able to get what you want in the international system going forward. So international law does have some hold, and court judgments specify the application of international law in a fairly authoritative way. And therefore, they provide a rallying point for those who are seeking to halt justice. But they also provide political cover for actors who have constituencies who are not in agreement with the outcome. But the political actors can say, well, whatever you might think about this, this is what we agreed to. This is the law. It's been specified by a court. This has to compel our action. And it also can broaden the constituency for a kind of political objective, in that it can win over people who are not with you on the merits, but who nonetheless have reason to care about law abidingness in the international system, and so will get behind you on this matter, precisely because the significance of international legal constraint is significant from the point of view of their long-term interests. And so I would say for that reason, the actions of international courts are important in these circumstances. They provide a certain amount of leverage. They're not going to solve the problem. They're not going to be enforced in direct ways. Even if an arrest warrant ends up being issued against Benjamin Netanyahu, as has been proposed by the Office of the Prosecutor, and if the pretrial chamber accepts that, the warrant will issue, but it will probably never be executed. Still in all, this would have, I think, a significant effect on the international politics, on the politics of various countries that have leverage in the situation. And therefore, international courts, I think, play a role in constraining conduct, even if they cannot be relied upon to solve our problems. So that was all very long-winded, and I'm open to your questions, but hope that I've laid enough out for you to give you a kind of general overview. Thank you.
Thank you, Brad. I'm swimming in all this stuff, and so my first question. Other people have questions. Please put them in the chat, and I'll share them. Is there a book or two you might recommend for the non-lawyer to really get a good overview of what you just summarized in an hour's presentation?
Wow. It would take me a while to think about it. I really can't think of particularly books for non-lawyers that really summarize all of this. And a lot of the stuff that you do, people who are motivated to write books like that often write them kind of tendentiously. They want a particular set of outcomes, and then they're sort of massaging the complexities of it in order to get what they want. So I would be the more straightforward the account, the more suspicious of it I would be. But I can't, unfortunately, nothing pops to mind as a quick and dirty source on all this.
How about a more periodic source? I've been going the last 6 months or so more frequently to a website called Just Security that seems to be written by international legal players. Is that, or are there other kinds of things like that that one would look at to?
Yeah, and with topical matters as they come up, there are a number of websites that are good for that purpose. Just Security is pretty good. There's one called Opinio Juris, which is based on this fundamental term in international law about how you find international custom. Opinio Juris is one. The blog of the European Journal of International Law, it's called EJIL Talk, is actually, I think, the best of them. It has some of the most prestigious authors who do blog posts for them. And so there are a number of these. I'll try to think of some more. There's one called Lawfare, which, as the name tends to suggest, it tends to lend itself to more conservative views. Lawfare is no longer the pejorative that it initially was, but the original use of the term lawfare was this idea that this was kind of the weapon of the weak to take advantage of powerful democracies concerned for law abidingness and using law to undermine their war efforts and so forth. But Lawfare isn't as bad as that. It's actually a pretty good blog with serious scholars who speak to these questions.
And I see Samantha just put those in the chat for us here, so that was good. One other question I had, I think you might have answered it, but I lost it in there somewhere. Are there any real enforcement provisions with either of these courts?
So, well, it depends on how you look at it. So on the one hand, the only real hammer there is in the international system is the UN Security Council, when it can take a decision with 9 out of 15 affirmative votes, and crucially, no vetoes from any of the permanent 5. And in these cases, there's always going to be a veto, so that's going to be a problem. The other form of coercive implementation can be, of course, people can be arrested on international arrest warrants. Whether states are actually willing to do that or not is another question, even if the arrest warrant is valid. There is a problem with the most high-profile arrest warrant cases here. There's been an arrest warrant issued against Vladimir Putin for the taking of children out of Ukraine, which is a criminal violation of the law of war. There'll probably be other crimes that will be added to that. And then there is a request to the pretrial chamber to issue an arrest warrant against Netanyahu and against his defense minister, Yoav Gallant, for their actions, particularly with respect to restricting food supplies in the occupied territories, and there are other matters as well. The problem is that, as I mentioned before, there is this immunity of heads of states, heads of government, foreign ministers, and ambassadors. And so it's called immunity ratione personae. It is immunity of their person, irrespective of the kind of act that they've committed, as long as they are in the role that they're in, because of the international concern for diplomacy. International courts see themselves as an exception to this rule. Foreign states can never exercise jurisdiction over sitting heads of state, heads of government, and so forth. International courts can, however, there's a problem because if a state is not a party to a treaty that has waived the immunity, then the immunity still imposes an obligation on the state that might execute the arrest warrant. And so if I were the defense attorney for Netanyahu or for Putin, and there was a prospect of one of them being arrested under the terms of an ICC warrant, I would argue that because they are not states parties, they have never waived, those states have never waived the immunity of these officials, and therefore they cannot be arrested, that the arresting state would be violating an international legal obligation that can't be overridden by the ICC. I think that's actually a pretty good argument, but I think it's a political question as to whether states would go one way or the other on that. In any event, I think the politics of it make quite clear that they wouldn't be arrested. And I think that other officials who are not going to be subject to that immunity are probably not going to get arrested either, particularly not Israeli officials in any of the places that Israeli officials would actually travel to. So in terms of coercive implementation, there are real limits.
Okay. Are there any other questions out there? I'm not seeing anything else in the chat. It's late in the day for Dr. Roth, so we can let him go. But if you have a question, he's been so willing to stay up late to be able to share this with us. I'll give you another minute to come up with another question. I don't want to hog them all. I did just recently pick up Richard Falk and what's the guy? And Hans von Sponek have a new book out called Liberating the United Nations, Realism with Hope. Have you happened to see that book?
No, I haven't. Falk is, of course, a legend.
Yeah.
And I was at a conference with him a few years ago on the question of Palestine, which is a very controversial conference, and he is a very controversial figure, particularly on that question. But he's one of the grand old men of international law, and always someone worth listening to.
The other author is a former UN Assistant Secretary General and served as UN humanitarian coordinator for Iraq.
Mhm.
And so it's really look at kind of the role of the United Nations in international law. I'm only 100 pages into it, but
Mhm.
it's interesting.
Mhm.
Well, I guess we're going to let you go. No other questions. I think we're overwhelmed by what you were able to share with us in that short time. And I think some of us might want to go to law school, but my daughter did that. I'll leave that to one member of the family. Really, really appreciate all that you've done. Why don't we unmute everybody and let's give him a round of applause that he can take to help sleep well tonight. Thank you, Brad.
For me, I got a lot of benefit.
Thank you. Lots of thank yous.
Okay. All right.
Excellent.
Thank you so much.
All right. Take care. Sleep well. I hope the weather changes for you.
All right.
I have a question.
Okay.
I I am wondering if there's any chance of a case being brought against President Biden.
In principle, yes. In reality, no. But the one is the law and the other is the politics. It's a very good question because it goes to the matter of aiding and abetting. The International Criminal Tribunal for the former Yugoslavia has dealt with aiding and abetting cases. The dominant view is that if you supply people with the wherewithal to commit an international crime, that even if it is not your purpose that they commit an international crime with that material, if you know that they're committing international crime with that material, that you can be criminally liable. The ICC cannot prosecute that because the standard in the ICC is purpose. There's a big question about aiding and abetting as to what we call the mens rea, or the guilty mind. Do you have to actually intend for the purpose? Do you have to actually have be purposive in your aiding and abetting of the crime, or you just have to know that what you're supplying is going to be used to commit the crime? The dominant view in the ICTY, although there was split decision on that, was that knowledge was enough. So if a state is exercising universal jurisdiction over these matters, as they can under the Geneva Conventions, grave breaches of the Geneva Conventions can be prosecuted anywhere in the world. In principle, the president, particularly after he steps down from being president, he ought to be careful where he goes abroad on vacation. Now again, would it actually happen? No. It didn't happen in the global war on terrorism, where there were a whole bunch of people who were very, very much potentially subject to criminal prosecution, and it never worked out for one reason or other. But the possibility does, in principle, linger there.
Thank you. I watched I think there were Palestinian families that took the government to court in San Francisco.
Yeah.
And they didn't have jurisdiction.
Yeah, so that's another problem, which if we had more time, I was going to go into, which is that, again, there's this difficulty of getting U.S. courts ever to use international law against the United States government. And it almost never works for a whole series of reasons. The last refuge of scoundrels in all of this is something called the political questions doctrine. And that was what the court used to dismiss the case in California. And so the case was brought, based upon existing U.S. law. But the problem is that cases involving sensitive questions of foreign policy can give rise to this invocation of this rule against justiciability of cases where either it will cause embarrassment to the United States for the country to speak with more than one voice on the question, or where the interpretation of the law or the facts are seen to be based upon kind of non-judicial forms of knowledge, that there needs to be some sort of policy decision that has to be undertaken, or a kind of fact-finding like intelligence findings that are not within the scope of judicial competence. So things like that. And it really, it's sort of a nonsense doctrine. It really is just a way for courts to dodge legal questions. And one of the things that's irritating about it is that they could get away without using it because there are so many other bases that they can use for avoiding these questions. The volume that Greg Fox, Paul Dubinsky, and I co-edited was called Supreme Law of the Land ? Because under the Constitution, treaties are supposed to be part of the supreme law of the land. But in practice, for all kinds of reasons, they are almost never effective against the U.S. government in U.S. courts. And that's for a whole host of reasons that I could go into at great length. But the bottom line is that international law really is not effective in U.S. courts against the U.S. government, except insofar as the provision might be incorporated into a U.S. statute. And that sometimes happens. And in fact, there was one important case during the global war on terrorism called Hamdan versus Rumsfeld, where by the narrowest of majorities, the court did hold that the Uniform Code of Military Justice codified a fundamental principle of the Geneva Conventions, and therefore established that certain kinds of treatment of people who were in a non-international armed conflict were subject to regulation. The thing that the case was ostensibly about trying people in military commissions, but the real implication of it was the impact on torturing people. And what happened bizarrely was the court held that something called Common Article 3 of the Geneva Conventions applied through the Uniform Code of Military Justice to the Bush administration. That sent them into a panic, because not so much because of the military commissions, which is the subject of the case, but because everything they'd been doing in terms of enhanced interrogation techniques was premised on the non-applicability of the Geneva Conventions to the people who they were holding in custody. And everything they were doing, not just the torture, but cruel treatment, humiliating and degrading treatment, all of that is a crime under the War Crimes Act if the Common Article 3 actually applied. How did the US Congress respond? It retroactively amended the War Crimes Act so as to decriminalize the conduct under which people would have been prosecuted.
Oh,
Yeah.
with that.
Yeah.
Oh, yeah. Well, thanks again, Brad. Appreciate you expounding. I'll be following your work.
Well, thank you so much. It's been great
Okay.
doing it.
Yeah, you too.
Thank you very much.
Sleep well. Samantha,
Okay.
thanks so much for managing the show today.
Oh,
No
yeah.
problem.
All
Take
right.
good care.
Good job.
Yeah.
I'm
Bye.
going to sign off.
You too.